on the Guam U.S. military relocation, public safety, and judiciary of the 33rd Guam Legislature is hereby convened for the information of the public. The items on the agenda is the item on the agenda is Bill number 149, that's 33 COR, which is relative to parents' liability for willful acts of minor children. In accordance with the public notification requirements, on Tuesday the 25th, the initial notification was circulated to stakeholders, the media, and to the senators in the Guam legislature. On the 27th, due to the scheduling of session, that particular time frame originally scheduled for 2 p.m. was moved to 5 p.m. and that notification was forwarded to all the stakeholders, the senators, as well as to our media partners. The second notice was distributed on Friday, the 28th of August, and we now will proceed with the agenda, which is, like I mentioned, a singular item, Bill number 149-33, who's sponsored by the Honorable Senator B.A. Atta and F. Bloss Jr. Senator Atta, if you would like to provide comments on your legislation, and then we'll proceed.
Thank you, Mr. Chair. Mr. Chair, Bill 149-33 COR is an act to add a new Article 7 to Chapter 24 of 7 GCA relative to parents' liability for willful acts of minor children. And what this bill does, Mr. Chair, is that it will enact a parental responsibility law for Guam. As you know, that every U.S. state has laws that hold parents and guardians civilly liable for the willful acts of their children. Guam and District of Columbia are the only exceptions. Many of Guam's criminal and civil liability statutes hold individuals financially liable to the government of Guam for damages caused by illegal acts, such as criminal mischief, vandalism, property damage, and bodily injury caused by the commission of a crime or tort. You know, Mr. Chair, when I was the director of Department of Youth Affairs, I would always hear from employees, law enforcement, prosecutors, and defense attorneys that there are no bad kids, just bad parenting. We have many laws that hold criminals personally liable or require that restitution be paid. The problem is, if the offenders are unemployed minors, there's little recourse available to their victims to obtain restitution. Bill number 149-33 will give victims the same rights as those in all 50 states, Puerto Rico, and American Samoa have. And that is the right to recover through a civil action from the parents and minors who willfully commit crimes or tort. As with many Guam laws, the state of California served as a model for this bill. The limits of liability contained in the bill against the parents and those parents who might be insured are based on California law. I should point out that there are many states that have no limits of liability, including Hawaii, the closest state to Guam. That would conclude my answer.
Thank you very much, Senator Atta, and Mr. Vice Speaker, thank you for joining us this evening. There's been a request that the testimonies be read, so just for the record, at this point in time, we've received written testimony by the Judiciary of Guam as well as the Office of the Attorney General. And the first one that I would like to read, and then I will yield to the sponsor of the legislation and ask him to read the version from the Office of the Attorney General. This is the Judiciary of Guam on Bill number 149-33. On behalf of the Judiciary of Guam, thank you for providing me with the opportunity to submit written testimony regarding Bill number 149, which was sponsored by Senator V. Anthony Atta and Senator Frank F. Bloss, Jr. My testimony today is limited to subsection C of the proposed bill, which discusses the role of the Judicial Council. The Judicial Council is prepared to meet the obligations imposed in subsection C if the proposed legislation is enacted into law. Namely, the Judicial Council will execute its duties and review the liability amounts every 2 years, which amounts are currently set at $25,000, and adjust the liability amounts as necessary by referring to the Guam Consumer Price Index or other similar authority. Although my testimony is limited to the Judicial Council's role in the proposed bill, I do note that there is an existing statutory provision found in Title 18, Section 90113 of the Guam Code Annotated, which discusses the civil liability of parents in actions involving destruction or damage to property as well as personal injury. Thank you again for the opportunity to provide written testimony on Bill number 149-33. As noted, the Judiciary of Guam stands ready to undertake the duties contemplated in subsection C of the proposed legislation, signed by Dana A. Gutierrez, Director of Policy, Planning, and Community Relations. The committee did receive a second written testimony, and I'd like to yield to the sponsor of the legislation and ask him if he could please read it for the record.
Thank you, Mr. Chairman, and this is from the Office of the Attorney General, Aguon. Dear Senators and members of the committee, this written testimony is submitted on Bill 14933, an act to adopt a Aguon parental liability law. Most parental liability laws were enacted to curb juvenile delinquency throughout our nation. The theory was premised on the belief that if parents were made to pay for the wrongful acts of their children, it would force them to become better parents and thereby reduce juvenile delinquency. Unfortunately, juvenile delinquency has not declined. Nonetheless, most states have some form of parental liability legislation. It appears that Bill 149 was taken almost verbatim from California's statute, Civil Code 1714.1. The problem with taking one portion of another jurisdiction's statute is that it often fails to take into consideration other corresponding statutes, such as California's Penal Code 272, making it an act of contributing to the delinquency of a minor a misdemeanor crime, or California Welfare and Institutions Code 730.1, making parents liable for restitution and fines imposed upon a minor via the juvenile court. All these statutes work hand in hand within the same concept of parental liability. Bill 149 is just one component of a broader approach and review of parental liability. It focuses solely on providing a civil course of action for damages. This means that a victim would have to file a civil lawsuit to claim damages for losses due to a juvenile's wrongful acts. A civil lawsuit is not always an expeditious path to recovery or restitution. Should the bill pass without further consideration to other corresponding statutes, our office would recommend that certain terms be defined. What is meant by custody? Does this include both legal and or physical custody? Does parent include persons who stand in local parentheses to the child, as well as institutions who are ordered legal custody or foster parents? What does control mean? Does injury to property include taking of property, theft? Do parents have defenses, as in common law? At common law, parents could not be held responsible for the wrongful acts of their minor children unless they participated or directed the acts. This is reasonable. The bill does not provide for any defenses. It sounds almost like strict liability, which seems far too harsh. We support the enactment of parental responsibility laws in a manner that brings about real victim compensation, but also balances punishment where punishment is most deserved. It is recommended that juvenile judges be allowed to make those kind of determinations by empowering them to order parents to pay restitutions, fines, and government costs associated with juvenile delinquency dispositions based on their ability to pay, their culpability, or neglect supervision. Thank you for your time and consideration. Sincerely, Elizabeth Barrett Anderson, Attorney General.
Thank you very much, Senator Ada. Just on that note, the committee has received 2 written testimonies, and the committee will continue to receive subsequent testimony for the next 10 days, and then we will close out on the committee report for Bill number 149-33. Thank you very much for your attendance, everyone. Have a good evening.